Hey, welcome to the show. Yes, indeed. This is a great show. It has to do with the law, and we call it Law 2020, brought to you by your friends, and I do mean that, your friends in the offices of the BCN Law Firm. That's right, BCN Law Firm. You'll be hearing on this show from Wade Boyette. You might be hearing from Eileen Mazanets. You might be hearing from Heath Nalos. Brian Monk is with us today, and we're taking your legal questions right now at 855-297-9696. If it's not something that is right down the alley of Attorney Brian Monk, he may have general knowledge of it and or be able to get you on the right track toward the attorney with the law firm that you can contact first thing in the morning, and you can use the office number of 855-LAW-2020, or you can use, since there's no long-distance charges anymore on phones, if you're using a smartphone, 352-394-2103, 352-394-2103. Remember back in the day when we had to worry about long distance? Oh, that's something in our past. That'll age you real quick. Law 2020, that's the name of the show. So if you want to call in the show, it's 855-297-9696, toll free from anywhere, 855-297-9696. You could open mic a question to the app on your phone. It's called News 96.5, and it has an open mic button. How does it work? You just push that button, open mic, and then it says record, and you press the record button, and you go, hey, I got a problem. What's going on? And you just tell the problem. You got about 10 seconds. And you could text us at 21232, 21232. We're talking about family law today, and this is something that a lot of states vary in. So especially if you have moved here from another state, and now you're thinking about, separating, getting that divorce, whatever, the laws are a little bit different here. And there's a lot of things that you need to consider about spousal support. I'm one of those. There's just a lot of things that you need to know, and it's good to have attorneys on your side. So that's why we have Brian Monk here today. He deals with two things, family law and criminal defense. You're thinking, wow, boy, those are diverse. Maybe not so much. I can think of a few cases around. Hey, Brian, what is the role of mediation? I don't think a lot of people even understand. I think they just got to go to court. She gets an attorney, he gets an attorney, and let's go fight it out. But there is something in Florida called mediation. What's that all about?
Yeah, good afternoon. Mediation is a common part of the divorce process. Most jurisdictions require the parties to go to mediation before setting a final hearing. Some jurisdictions even require mediation before even a temporary hearing. Mediation, generally speaking, the parties go in two separate rooms normally, and you have the mediator who will give an opening statement, and the parties may be together for the opening. But then usually they split apart. It's called caucusing in two different rooms. You can imagine in a divorce case why it might be important to separate the parties. Mm-hmm. I've seen before, a heavy sigh or a cross look or just one word can torpedo the whole thing. So in my mediations, I even prefer to start separate right from the beginning. I was in a mediation last week that went for over or right around 13 hours.
Oh, wow.
And I would say in that case, they didn't even have kids to fight about. It was
really
property only for 13 hours. Happy to say at the end of it, everything was settled, but they can be time-consuming events. And people have an opportunity. They can either go to mediation at the courthouse if they qualify based on their incomes, or they can go to a private mediator. In this circumstance, we involved a private mediator. So when you have one attorney involved on each side plus a mediator at their rates, you can be getting into some serious money per hour for the parties. Mm-hmm. But it can be more affordable than ultimately duking it out with multiple depositions, temporary hearings, and final hearings. So even though it can be costly, if everyone comes to it with an open mind and a willingness to settle, most of the time mediation is successful.
Boy, that is amazing. So 13 hours of mediation, that got a little expensive, huh?
Yeah, it can get expensive, and you just have to, remind them. In fact, even at times, the mediator would remind the parties when they wanted to bicker about pots, pans, dogs, cats. Say, look, you're spending more for us to talk about it than it's worth. And it puts it in perspective for people.
Let's go back to one of the premise that a lot of new Floridians don't understand, or even new to the law. They're happily dating, they get married, maybe they've been in Florida all their lives, and then, they hit the wall, so to speak, and they find out that, Billy over here has been dating the girl at work, and they've had hotel affairs, and they took off for a cruise one weekend, and it's been really dirty. And the first thing that the wife might want to do is, I want to go to court, and I want to tell that judge just exactly what Billy did, and I want the kids because of that, and I want the cars because of that, and I want all of his money because of that, and I'm going to punish him for what he did. This is Florida. So tell us the difference.
Well, what most judges are going to want to know in that circumstance, because I've been in many circumstances like that, I've represented people on both sides of that fact pattern. The judge is going to look at you and say, what is the connection between Billy's conduct and the children, the interests of the children? If Billy's doing a bunch of bad things, but it has no impact on the kids, most judges may not be too impressed by that. Or from a financial standpoint.
So if the kids didn't know anything about it and she found out about it from a neighbor, but it didn't affect his income for the kids, it didn't affect his time with the kids, he was hiding this, he was doing it at work, it's basically a no-fault stay, right?
No fault when it comes to actually getting the divorce. The other thing the judge might care about from a financial standpoint is, did she buy Billy a $10,000 Rolex? Well, $5,000 of that is marital money that goes to her husband. So, if you're taking marital funds to spend on your significant other, yes, that can be relevant. But I've had some cases where people are introducing new boyfriends or girlfriends to the kids, and the divorce isn't even final yet. A lot of judges frown on that, don't find that to be in the kids' best interest.
All right, very good, Kathy. How can we help you today? Calling in at 855-297-9696. We want to remind you that's what makes the show, and we also remind you of one other thing. We're sensitive to your sensitivities. If you're going through something legally, you may not feel, either criminally or family law, you may not feel apt to give your real name. We don't have a problem with that. Make up a name, okay? Make up a name. And if it bothers you that you feel like somebody might recognize your voice, well, then use the texting feature at 21232 and send in 2, 3, 4, 5 texts, whatever it takes. You only have about 20, 27 words per text, but that way we get the full story. Kathy, we thank you for calling in. How can we help you?
Yes, I am recently divorced, and it states in my divorce decree that my husband was previously filing for disability, and it's been, while we were married, it was about a year and a half he was going through the process. And it states in my divorce decree that if he should receive a lump sum, that he owes me a certain amount of money. If I hire an attorney, if he had the qualifications to access that information for me, to whether he has been denied or accepted for disability.
Okay, Kathy, we're going to take a quick break, and we're going to answer that question right after the break. Please hold on to the line. We're up against 3 big things you need to know. And welcome back to the show, and we're 8 minutes away from news, traffic, and weather coming bottom of the hour. Let you know what's coming weather-wise, and triple team traffic. Wow, the roads in Central Florida, it can be a Sunday. It doesn't matter. Roads get tangled up around here all the time. So we keep you on top of that so you'll get there on time. And don't forget, tomorrow morning, you'll get to work on time and informed with the All News Morning Show, Orlando's only All News Morning Show, featuring Joe Kelly and company. That is like a drill team of news people. It is unbelievable. They just do such a magnificent job. And in just a few minutes' time, you are up to date. And several times an hour, the 5-day forecast coming your way. All right, we're taking calls right now for 855-297-9696. Texting is 21232. Open mic feature on the all-new News 96.5 app. That's 3 big ways to get a hold of the show. Hey, Kathy, restate your question once again, and we have Brian Monk ready to attack it.
Okay. I'm recently divorced, and before my divorce, my husband had been filing for disability, going through the process for about the last year and a half. And it states in my divorce that if he receives a large distribution from Social Security Disability, that he owes me a certain amount. If I hire an attorney, does he have access to the information, whether he has received his distribution or he was denied Social Security Disability?
Thank you for the question, Kathy. Certainly, if you get an attorney involved, the family law attorney's remedy is going to be ultimately to file a motion to enforce with the family law court, because that's what you're trying to do, is enforce one of the dictates of the final judgment. Certainly, the rules authorize the attorney to issue subpoenas to entities to recover, to discover documents like that. If you are unable to ascertain the answer to that yourself, either by contacting your former husband directly or writing him a letter, certainly the attorney involved may want to just write a letter first or try to reach out to him. But if he says, no, I don't have it, and you don't trust him, certainly try to go directly to the agency under Freedom of Information Act and see if they'll disclose whether or not there was an award. Based on the Freedom of Information Act with Social Security claims, they're not going to give you his whole file. There's a bunch of medical things in there. But
Right.
they should be able to let you or an attorney know whether or not there was, in fact, an award distributed. So,
Okay. And also, I don't know if you can answer this or not. Somebody kind of indicated to me in a roundabout way at the Social Security office. I don't know. He made good money. I don't know what his lump sum would be. You know, he's been applying for almost 2 years. And his amount to me is a small amount. It's a couple $1,000s. She told me since I was married 15 years that I might be entitled to more than that.
yeah, if you're married at least 10 years and you're not yourself remarried, go take a look at the website, ssa.gov. They lay out what rights you may be entitled to based on a bunch of different factors, your income, your eligibility for benefits, length of marriage. You have to have been married at least 10 years. So I think she's pointing you in the right direction. I've looked at that website recently, and it's pretty clear the way they've laid it out.
Okay, I appreciate that so much.
You're welcome. Good luck to you.
All right, thank you. Let's go to Scott. Scott, we got about 5 minutes. Let's use it wisely. You are on the air with BCN attorney Brian Monk. Go ahead.
How you doing? Thank you for taking my call. I had a question with regard to alimony in the state of Florida. You've been married 20 years, and I think a lot of people stay together for the kids and all. But what happens with regard to alimony when the kids are grown and you decide to separate?
Well, alimony is going to be based on your wife, if she's the one seeking alimony, her financial need and your financial ability to pay. So a lot of times when people are divorcing and there's young kids involved, there's a child support component that's there to sort of offset the children's needs. That amount may go to the spouse. But what you're saying is it would be just her involved, no concern with the children's financial needs. She would have to prove up to the court, and we use financial affidavits and family law. She would have to prove up to the court what her financial needs are. The court will take a look at, your standard of living during the marriage, and there's other factors the court will consider. But the main starting point for the court's consideration is what is her financial need. She may be under retirement age, healthy, able-bodied, able to work, maybe have certain degrees or an ability to earn income. All of that comes into play when determining alimony.
Okay, and what if she refused to work for a number of years, and you're taking a look at your income versus her income? How does that play into it?
In Florida, you or your attorney could ask the court to impute a wage to her, and imputation is, convincing a judge that she's able to earn a certain amount of income. It's a shorthand way to do it, and a lot of judges do it, and a lot of attorneys stipulate to it, is they say, well, can this person earn at least full-time minimum wage salary? And if the person, is sort of at that range, most people will stipulate and say, okay, this is about what they can earn. If you think the person can earn more than that, but they're not, it may be difficult to prove, or you need some evidence to prove it, a lot of times people hire vocational experts, people you can actually get involved in the case to conduct interviews with her, to do sort of an analysis that matches up what her abilities are with what the available jobs are in the market. So that's another tool. You can't just walk into court and say, well, I think she can earn more money. You have to be able to convince the judge, specifically what she could earn.
All right, very good. Thank you so much for the call. If that sparks a little bit of a thought on your part as to a situation that you might be in, go ahead and give us a call right now at 855-297-9696, 855-297-9696. You could always text us at 21232 or go to that all-new open mic feature. That's open mic feature on your News 96.5 app, available on any kind of a smartphone device. All right, we're down to about 2 minutes, and let's get on with our questioning here. Let's see. Are depositions required in a divorce case, and what are we to expect if we're asked to do a deposition?
Depositions are not necessarily required. Deposition is something that either side has the right to do in a divorce case, to conduct what's called discovery. A deposition, generally speaking, I get this question a lot. What is a deposition? You have a court reporter, you have the other party or the other attorney, and then you have the person being deposed called the deponent. And the person who's being deposed is sworn in, and they're asked questions. And the questions you're asked are supposed to be questions that may be relevant to a material issue in the case. And because you're under oath, the significance of a deposition is the statement you give under oath in a deposition can later be used in court. So if in court, you say, I've never had a girlfriend during the marriage, and in the deposition you say, well, yes, I had a girlfriend during the marriage. Later in court, the attorney or the other party could bring out your prior inconsistent statement that you gave during the deposition. So people use it mainly for two reasons: to kind of see where the other side is coming from in their case and in their strategy, as well as to impeach them on any prior inconsistent statements. So if they give a statement later that's not consistent, the deposition, can be used against them later.
All right, very good. We're down to our final minute of the half hour, and then we're going to come back for another couple of segments with attorney Brian Monk of the BCN Law Firm. During the week, you can call them at 352-394-2103. A few minutes of free consultation is available to you at 352-394-2103, 855-LAW-2020. That's 855-LAW-2020, just like the song says. The website is bcnlawfirm.com, bcnlawfirm.com. And again, don't forget, we're here at noon every single Sunday on News 96.5. Welcome back to the show. Yes, indeed. This is called Law 2020. Law 2020 brought to you by the offices of the BCN Law Firm. You can actually see this show on the all-new YouTube channel, BCN Law Channel. BCN Law Channel, and you'll see Brian Monk just later on this week doing his show right here. You'll hear this voice off mic, who happens to be me, but no pictures of me. That is not allowed. All right, we're going to go to Mike, and we'll take your calls at 855-297-9696, 855-297-9696. You could text us at 21232. If you've got a question and you're afraid somebody will recognize your voice, especially, but if you don't mind your voice being on the radio and you still want to ask your question and then go about your business, let's say you're barbecuing or whatever, just go to the all-new News 96.5 app. Ask your question, set your phone down, and you are on your way. Mike, once again, what is your question?
My wife moved to another state and filed for divorce, but she left me with the mortgage and all the bills and makes 3 times as much as I do. What can I do for that to put it off on to help her with the mortgage and get her to help with things?
Mike, do you you live in Florida, obviously. Do you also want a divorce, or do you not want a divorce?
I don't want a divorce.
Okay. And, I know the other state, I think, was mentioned off the air. I heard that, and I don't practice in the other state. But what I can tell you from what I know generally, most people in other states, if they're seeking to file, can get the actual divorce. But for that state to go ahead and act on property in another state is difficult, sometimes not even possible to do. They may not have jurisdiction over the property or you to be able to do that. Florida courts have jurisdiction over you and her and your property. That other state that she moved to doesn't have jurisdiction over your property or you, just her. So she can get her divorce, but that might be all she's able to accomplish. So, if she's, you're married and you want some assistance, there's a statute in Florida called support unconnected with divorce. And so you can actually file, it's similar to a divorce action. She gets served, you lay out your respective incomes, you lay out the situation to the judge in your pleading, and it's called support unconnected with divorce. And the judge can order, in this case, it would be alimony. If you have any kids, maybe child support, but if it's no kids, just alimony, in order to address some of your financial problems of her essentially abandoning you. I will tell you this as a word of caution, 99% of the time when a support unconnected with divorce suit is filed, the response is a divorce case is filed right back. And you already know that she wants to file. She's just filing in the wrong place, quite frankly. So, but yeah, you can seek out the assistance of an attorney and see if you can't get a support unconnected with divorce claim filed. A lot of people don't know those are possible.
Okay, thank you so much. Again, we do want to remind you that BCN Law Firm now has offices in Winter Park, Claremont, Lakeland, and a brand new office on Highway 466 in the Villages. So if you're up that way, let's say you live in the Villages or Spruce Creek or Wildwood, Leesburg, Mount Dora, Eustis, right on up there into Bellevue and Ocala, you're very welcome to use the all-new office in the Villages, conference room facilities, everything you want. And it's right there on Highway 466. Can't beat it. Runs between Highway 441 and 301, not far from the Turnpike.
Yes, sir. I used to be a prosecutor up in Ocala for a couple of years.
Really?
And I still get some referrals for cases up there.
Cool.
Got a handful of family law cases going there now, and I told them and my network and friends up there that we have an office coming near the Villages, and they were very excited to hear about that.
Very cool. I was glad to be a part of that. Very neat.
Yes, sir.
Okay, Neil, how can we help you, bud?
Yes, good afternoon. I got divorced about maybe 6-7 years ago, and we filed like a quid pro to get access for my wife to get my ex to get my 401k, but we made a mistake, me and my former lawyer, and gave her access to my retirement, and then we later fixed it and gave her access to my 401k. We got that, split that up. But now I'm wondering, it's probably time for me to look about going back and fixing that original problem before that becomes a problem when I get ready to retire, if you know what I mean.
Well, yes, sir, I do. I haven't heard of that problem before, but I'm not surprised that it happens. You called it a quid pro. I think you mean a quadro, QDRO?
Yeah.
Qualified Domestic Relations Order. So this is an order that usually gets entered around the time of a divorce or shortly thereafter. It's a way to divide retirement accounts from 1 into 2 so that nobody has any tax penalties or anything like that. What this gentleman, Neil, is saying is that they applied the quadro to the wrong account. I can see that's a problem. What you'd want to do is have an attorney take a look at the incorrect order and what about it was incorrect, and see if you can't figure out with your company what effect, if any, it's had on your retirement plan, and to see if another order correcting the prior order needs to be entered or if that prior order needs to be vacated. So it would require taking a close look at what the wrong order said and what effect it had on your plan. But it's good that you figured that out now, and I do think it's the right time to sit down with an attorney and figure that out. That's an interesting situation. Hopefully you're able to head that off before it becomes a problem.
Neil, did you have a follow-up?
Just don't be surprised if you hear from me.
Yes, sir. Yeah, I'd be glad to help you. Yeah, thank you, sir.
Very good. If you do want to contact Brian Monk, just do so this week at 855-LAW-2020. That's 855-LAW-2020, or you could dial 352-394-2103. That's 352-394-2103. If you want to text us, you can text us at 21232. Give us a call, 855-297-9696. Brian.
Quadros are interesting. I think they intimidate a lot of attorneys, or maybe attorneys just don't want to deal with them. I've always drafted my own quadros for this very reason. There's whole other businesses that have popped up that just draft these quadros, these qualified domestic relations orders. But that's one, Neil's call is a great example of why, as an attorney, you want to have as much control over drafting the documents, either in your client's favor, or if not in their favor, at least protecting them. So you see in this case, something was drafted just incorrectly. It was an error. So, maybe his attorney or whoever, had they not outsourced that, might have been able to catch that error before it crept up and became a problem for him. So, I know, So that's a common thing attorneys outsource, but it's better to do it in-house if you can.
Ouch. Okay, here is a text for you. Divorced and then remarried, had 2 children in the first marriage, am a disabled vet. She, meaning the first wife, is trying to get more child support than is paid, and I cannot afford my mortgage or even my electric. What do I do? That comes from, we won't even give his phone number, so we don't give that away.
Okay, it's a text message. So, saying somebody's trying to get more child support, if they're going back to court, a judge is going to take a look at if there's a statutory, a legal reason to give more support. What it almost sounds like he's saying, though, is he can no longer afford the support that he even had from the beginning. One thing people don't realize, a lot of people think that if you have subsequent children, the mere fact that you have more kids is going to diminish the amount of support that you owe previously born children. And the law specifically says no to that. You can't keep having kids and then say to the judge, well, I have more kids, so I can't pay support. At the same time, ultimately, the court should adjust child support based on what a person earns or is able to earn. So that's what it comes back to, is what you're earning, what you're able to earn. So when people get laid off or fired or their income changes, they need to get their modification request in right away, because when you finally get in front of a judge, they can give you credit only back to the date you filed. Ooh. So I've had people come to me before that had been laid off years prior, and I said, well, if you had just come earlier or had just filed when you first got laid off, you could have gotten credit back to the date you filed. So that's, you need to get that filed right away. Seek counsel if you have a situation that changes your income.
All right, very good. And again, let's see, 0641 did write in, and they're now thanking us because Tim got right on the ball there. And they just asked, what are the contact numbers? 352-394-2103 is the office. That is 352-394-2103. Or you could always go to 855-LAW-2020. You can sing that song to yourself, and then you know the phone number for the rest of your life. It's kind of like It's a Small World at Disney, a tune you'll never forget. If you just ever heard the commercial, 855-LAW-2020. I'm not a singer. I won't even attempt it. But you can just say it to yourself, and all of a sudden you're singing it because you've heard the commercial. 855-LAW-2020. The BCN Law Firm, offices throughout Central Florida ready to serve you. And guys and gals that are so community locked in. I mean, they're into everything when it comes to helping the schools, the communities, nonprofit organizations, fundraising, from the Wounded Warriors, doesn't matter what it is, they're helping with it, all in a good cause for a good community. 1248, when we come back, more of your calls, 855-297-9696. Your text, 21232. And not one open mic yet at News 96.5. What's going on out there? I'll be back. Okay, we're back. We have 6 minutes to go before news, traffic, and weather. We had an interesting text from somebody who wanted the phone number. We've had 2 or 3 texts in that case. One of them said they want to start divorce proceedings tomorrow. Well, I'm going to touch on that with Brian Monk here in a minute on what your first steps need to be. What are some of the things you need to be doing if you're thinking this thing is going to hit the wall and it's not going to work? What are some things you can start doing to, make sure that you're covered before you ever do something silly like pack your bags and walk out of the house and let them say later in a divorce case that you abandoned the household? Know it very well. It's happened to somebody very close to me. What are the 2 most common questions that you get in a divorce case?
When I first meet with people, I would say just about every consultation, people at some point ask me, how long is this going to take?
True.
And how much is this going to cost? And the reason those are good questions is because nobody can really give a definitive answer on either of those questions. The only time an attorney could tell you how much it's going to cost is if they're giving you a flat fee. Occasionally, in certain cases, I'll offer clients a flat fee. A flat fee means they're paying a flat amount they're not paying by the hour. In family law, most attorneys do those cases with an hourly rate, so that once you get to the point where you're discussing that with clients, they naturally will say, well, how much is this going to cost? Well, and it depends on if they get an attorney. It depends on what that other attorney does, what their approach to the case is. If you got attorneys involved and clients involved who want to try to settle the case, then it's going to cost less. If you have attorneys and clients involved who want to fight, have their day in court, depose every possible witness about every possible issue, that could get very expensive. And so it's sort of a related answer. It really depends on who's involved to determine how long is it going to take and what is it going to cost. So those are great questions, and you just have to kind of explain to people it really depends on what your goals are for the case, client, and it depends on what the other attorney involved decides to do and what the other party decides to do. Usually at some point with decent people involved, you can encourage them to participate meaningfully in mediation and get them convinced that ending their case, as early as possible is in their best interest. But a percentage of the cases, a percentage of the people need to have their day in court, or there's just something they can't agree on, and that's what the judges are there for. But, a lot of times the judges will say, many times, a judge will say, look, you guys need to work this out. You want to decide this more than you want me to decide this. I've heard many judges say that.
Two scenarios come to mind. One is, what if a couple has a very amiable relationship and they say, you know what, this just isn't working out. We thought it would. Family really wanted us to get married. Friends wanted us to get married. Wedding sounded like such a great idea. And I'm sure there's people out there right now going, man, he's reading my mind. And we just need to look at each other, over a public dinner and just say, hey, let's start the wheels on getting this thing taken care of. Do they still need an attorney?
I have a lot of people that call me in that circumstance, and I do recommend getting an attorney involved because, the simplest way to put it to people is you don't know what you don't know. And the more moving parts there are, the more pieces of property you have, or if you've got children, all those different issues, you might say to yourself, well, I don't mind all that. I just want to do this. But then there's a trap there for down the road, because if it's all amicable at the front end, it may not be down the road. And so 80% I think of a family lawyer's practice is post-divorce cases. If you even look at the calls today, I think most of the calls were about people that have already had their final judgment of divorce. So that alone should tell you most of the issues we deal with are post-final judgment. So just getting to the finish line of getting any old final judgment is not the goal. You want to make sure your rights are protected. You want to know what they are. You want to know what you would likely get if you were to go to court, within a range of reasonable possibilities. And then you can intelligibly settle your case and put it in writing in a way that will be enforceable and protect you later.
When you start seeing that there are irreconcilable differences, which is a bottom line the judge usually uses, is it good to, what preparations do you need to start making? We've only got a minute and a half. And is one of those first things to go see an attorney and just have a free consultation?
Yeah, why not? There's so many family law attorneys out there that will give you free consult. Do some internet research and find an attorney you feel comfortable with. Lots of different people can do this job, so it's important that you find someone who's got the right fit for you personality-wise, as well as their approach, most importantly, their approach to handling your case. If you want somebody who's going to fight over every last detail and not try to get you to a settlement, a reasonable settlement, that's fine. There's lots of attorneys that'll do that, but it's going to cost you a lot of money. So you want somebody who is both reasonable and who will protect your rights to the end.
All right, so we're talking to Brian Monk of the BCN Law Firm, and you can call him tomorrow at 352-394-2103. That's 352-394-2103, 855-LAW-2020, 855-LAW-2020. Offices now, Winter Park, Claremont, Lakeland, and in the Villages on Highway 466. So all you people up north of here, Ocala, all the way down to Leesburg, you got your choice. And that's usually a very good location for you, centralized. If you're south of that, maybe the Claremont or the Winter Park office. Or if you're south of that, how about Lakeland? They got you covered right here throughout Central Florida. And we'll see you next week Law 2020 on News 96.5.